a topic that's never in the news and that no one really talks about, the Northern Ireland Protocol. And it brings me back to Lord Palmerston's quote about Schleswig-Holstein in the 1860s. No one really understood this situation. If anyone did understand it, one of them's dead, one of them went mad, and the other one's forgotten. And I'm not sure whether this has driven me mad or whether I'm the forgetful one at this point, because with the protocol and all of its iterations, I seem to be in the point of picking up more strands of it than can comfortably be held. And I think when we're unpacking the protocol and we're unpacking the relationship between international law and devolution, we're really seeing that happening to a lot of politicians in Northern Ireland and a lot of policymakers, even at UK government level. The strands of complexity of how devolution works, how not simply devolution, but power sharing works in the Northern Ireland context, and how they relate to EU law is a really complex jumble that at the moment we don't seem to want to get beyond sloganeering on, because sloganeering is easy and in terms of vote winning, and it seems to be the preferred option rather than having to deal with how this works in practice. So what I'm going to talk to you about today isn't the protocol. I'm going to take it that we all at least have a vague understanding of how the protocol works and the way in which it keeps Northern Ireland in a form of the single market in terms of goods. EU single market rules relating to goods continue to apply in the Northern Ireland context, and they can continue to develop over time. So Northern Ireland can be subject to new developments of the single market in terms of goods under the way the protocol is structured. And that's really all I'm going to say on how the protocol works, because I'm going to get on to the more vexed question of, well, what if that's not palatable to the UK government or to key parties within the Northern Ireland executive? What if the DUP and the UK government don't want Northern Ireland to be subject to the EU single market? And we can all throw our hands up and say, but that's the UK's international law obligation. Well, let's look at how that obligation works down to the obligations that sit on the UK government and on the Northern Ireland institutions in the context of the protocol debate, and what happens if the Northern Ireland institutions cannot take implementing measures because of disagreement over the protocol or because of key ministers seeking to block implementation. And what if the UK government is perfectly happy with that as a position and isn't doing anything to implement the protocol in and of itself? Well, this brings us back to the Withdrawal Agreement Act of 2018. And if you like, none of the provisions except for the bottom one here were in that 2018 Act. The first two were all parachuted into that Act by the 2020 Withdrawal Agreement. And they were parachuted in to create space to implement the Northern Ireland Protocol. So under Section 8, capital C, the UK government gets a power to make ministers as appropriate to implement the protocol. And then under Schedule 2, Part 1C, the devolved authority, in this case, the Northern Ireland institutions, have the power that it considers appropriate to implement the protocol. And here we, if you like, get into what was being talked about yesterday in terms of changes in what the nature of devolution is. We used to think about, well, pretty clear lines of demarcation between what was going on at a devolved level and what was going on at Westminster. They might not have been absolutely clear, but in most cases, you could divide up what was being done under the devolution settlement. And yesterday, as we talked about in human rights context, as the powers of the devolved institutions have expanded and changed, those lines of demarcation have become much less distinct. And it's not just in the human rights sphere, it's in the taxation sphere too. But here we have two absolutely overlapping powers. Everyone can implement the Northern Ireland Protocol. But how does that make sense? And what happens if one side wants to stymie the other in this process? Who actually implements the Northern Ireland Protocol if everyone is supposed to be implementing the Northern Ireland Protocol? And one last thing that I'll bring in, there is a restriction on the operation of this power. The Patten Amendment that came into the 2018 Act and was there whilst Theresa May was trying to get this Act passed. Now, under the Patten Amendment, there is a restriction that says that ministers and devolved authorities have to exercise their powers under this Act in a way that is compatible with the terms of the Northern Ireland Act 1998. So how much of a restriction is that? How are politicians starting to pull on the threads of how that actually works? So let's take a step back in a moment and think about what the protocol is and what it's trying to get politicians in Northern Ireland to do. Because the protocol effectively puts Northern Ireland in the same position as Norway or Iceland under the EEA, at least in terms of the single market rules for goods. Northern Ireland is a rule-taking jurisdiction. It, if you like, suffers from, benefits from what Norway or Iceland have described as rule by facts. They receive a facts from Brussels, indicating what a change or a development of the single market rules are, and the EEA countries have to adopt those rules. This is, if you like, not really a matter of having an active say in the creation or development of the single market. It is just administering rules that come in. Now, as we know, that plays differently depending on whether a regulation or directive is in effect, but it limits the scope for engagement that these jurisdictions have in terms of the way these single market rules operate. And in the context of the protocol, where its mere existence is so fraught, this form of engagement with decision making is almost guaranteed to turn politicians off. There isn't really a mechanism in the protocol whereby Northern Ireland's politicians get to show that they are competently engaged with EU law. There are closed door processes in the specialised committee feeding up into the joint committee, but no politician wants to look good behind closed doors. This is essentially being passed off to an official level, and executive office officials are attending these meetings and briefing on how rules and changes in the operation of the protocol or the single market would affect Northern Ireland. There isn't a direct reason, an impetus for politicians to engage with how this works. So instead, devolved politicians are doing, well, maybe what comes naturally. This is a recipe for grandstanding. When the creation of the protocol and its operation is so fraught, there isn't any urge to get involved in the working of the details of this. So we've got a system which deprioritizes political engagement in Northern Ireland with the way the rules work, even if it was a perfect system. And there was active consideration of Northern Ireland's viewpoint. Let's face it, jurisdiction that covers 1.5 million people is not really going to sway how single market rules operate. It will remain a fringe economy in much the same way Iceland or Norway's economies work. But there are ways that this could work much better. And if we continue with the protocol at the moment, one of the huge tension points in it is Northern Ireland's politicians have nothing productive to do. And if they have nothing productive to do, all that we're going to end up getting is shouting over the protocol. We are going to advance extreme positions over these rules. Now, one of those positions that's come to the fore since I wrote my abstract for this presentation is Jeffrey Donaldson, recently minted as leader of the Democratic Unionist Party, pushing his opposition to the protocol as potentially having devastating effects in Northern Ireland. Again, He has a difficulty in selling these devastating effects because the grace periods that he's talking about haven't come into an end. We're still in an era of protocol light, or, well, protocol partial in terms of its implementation. But what Donaldson is saying is that he is going to block any effort to make the protocol as a whole a reality within the Northern Ireland system. The DUP ministers would seek to block additional checks and reports. They will seek to block grace periods coming to an end, or any of the infrastructure, the checks that would need to be done to make the protocol fully functional. So we have a strategy here whereby, if you like, Northern Ireland is being pushed into a scenario of the protocol never working. Sort of never-ending war or constant renegotiation of its terms, and the DUP very happily situating itself in the center of this, saying we are actively going to do everything we can to prevent these rules from working. For now, well, that suits the UK government just fine. It doesn't want the protocol to work. It gets a lot of benefits out of being in a state of conflict with Brussels. For one, you have to remember the protocol, much as Boris Johnson accepted it and signed it, was his "this has to be done to get Brexit done" concession. It was a dirty job. Somebody had to do it to get Brexit through. He never owned that protocol. He has consistently tried to disown it ever since. So the UK government isn't a neutral actor here when it comes to the implementation of international law. David Frost is leading on a wide-scale renegotiation of the protocol because of its destabilizing impacts on Northern Ireland. So for as long as the DUP continue to be destabilized, it's feeding into the UK government's narrative that the protocol can't work. If you like, we have actors within the power sharing settlement and the UK government aligning to try to prevent the protocol having an effect. And if you like, a lot of the rules of power sharing in Northern Ireland make that effective. It is much easier to block something being done in the context of the rules of Northern Ireland's governance than it is to get something done. The disabling features of this constitutional order are prioritized. So maybe this is a legal strategy that will work. Jeffrey Donaldson certainly thinks so. But the UK government ultimately has the power in its hands to override the DUP's efforts to get around the protocol. In fact, that was baked into the 2020 Withdrawal Agreement Act and the way this is set up. That overlap in competence that I talked about a couple of minutes ago is entirely deliberate. It is designed to come into play in a situation where either Stormont ceases to function and we're into a direct rule scenario, devolution collapses or is collapsed under the weight of the strain of, well, pretty much the complete fracture between parties in Northern Ireland over Northern Ireland's place with regard to Brexit and the EU, or it's also in place if key ministers in the devolved and power sharing executive refuse to implement their role. And the key minister here is Edwin Poots in the agriculture brief, refusing to implement any infrastructure changes that might allow checks to take place, SPS checks in the context of the protocol. If either of those two things happen, well then under Section 8 capital C of the 2018 Act as amended, Westminster has the power to do all of these things. Now, in any other devolved context, this wouldn't make sense. You would say this is, well, clearly the UK government stepping into an area of devolved competence. But here it's not. The competences are shared equally. So any standard Sewell Convention, get off my grass line, doesn't really apply in this territory. And then secondly, you've also got the way devolution works as power sharing in Northern Ireland, allowing this to operate. If this was to happen in Wales or Scotland, with regard to Westminster, there are completely concomitant powers between Westminster and the devolved institutions. There would almost inevitably be a state of ping pong, where one side and then the other is trying to use its powers, trying to change or have priority given to its powers over it implementing these arrangements. But in the Northern Ireland context, if the UK government steps in and uses its powers to implement the protocol, it knows that that ping pong isn't going to happen. It would take alignment between the parties in the executive for the executive office veto to disappear. And that's even under the reforms to the executive office veto, the pocket veto that exists for the executive is simply not agreeing to ministerial decisions that were put into place last summer under the 2020 Act of the Northern Ireland Assembly. That blockage preventing or if you like, where the Northern Ireland parties don't come into agreement, creates space for Westminster to occupy this field. It exists because of Northern Ireland not having devolution, but having a power sharing system of government. So what is Jeffrey Donaldson getting at here? How is his strategy going to work? A lot of people said that this legal bit of the strategy is all flat. It's irrelevant because his threat ultimately to collapse power sharing arrangements is not something that Donaldson wants to do. It's not something he wants to do because the DUP is at a historic low point in the polls. But I'm actually going to take his threat seriously for a moment. I'm going to look at what he said in terms of the law, because I think it's not been looked at, and there's some really important legal understandings going in here in terms of how devolved authority works with regard to international law and Westminster works with regard to international law. There are effectively two strands to Donaldson's thinking. One, as in this quote, my ministers, DUP ministers, are going to block any additional check supports. Edwin Poots in the agriculture portfolio simply will not sign off on those checks. So step one, we are not going to exercise our powers. But then crucially, there's step two. The UK government isn't able to exercise its powers. Take a look at Donaldson's argument. Any of these checks would have a profound impact upon Northern Ireland. Under the Northern Ireland Act, a decision to intensify checks could only be implemented after decisions of the Northern Ireland Executive. In such circumstances, the Minister for Agriculture nor his officials have any power to intensify checks in the absence of executive agreement. Now that's the executive sign-off that I was talking about earlier as, if you like, a power-sharing lock that prevents ministers from doing solo runs in the Northern Ireland context. But what Donaldson is saying here has been missed, I think, in commentary on his speech last week. He is directly invoking the Patten Amendment under the Withdrawal Agreement Act of 2018. He is saying, and if you go back to section 10 that I flagged up earlier, that under the Northern Ireland Act, there is a need to modify the arrangements of that act or to change the Northern Ireland Act to bring that into being. And since Section 10 of the Withdrawal Agreement Act prevents any changes to the Northern Ireland Act, he's effectively saying he thinks there's legal reason that the UK government can't act. Now, if that's correct, there's a complete shutdown of both those limbs of enforcement, the devolution end of implementation and the Westminster end of implementation. Now, I don't think that game of pass the parcel is actually going to work. At a Northern Ireland level, it runs smack into the McNernn decision. Now, McNernn was about the compensatory or pension scheme that was put in place for anyone who was a victim of the conflict in Northern Ireland. And for various reasons, ministers in the executive office, both Michelle O'Neill in the Deputy First Minister role and Arlene Foster in the First Minister's role, had reason to dislike this statutory scheme that was put in place by Westminster. And that executive office requirement for sign-off or to bring the law into effect, to make changes, was being used to hold up the implementation of this rule. McNernn, who stood to benefit from the scheme, brought an action challenging that pocket veto by the executive office. And in this case, Mr. Justice McAlinden said, look, this is a legal requirement set out in a legislative scheme promulgated by the Westminster Parliament. The executive trying to just ignore its statutory duty is a shocking proposition. It either demonstrates willful disregard for the rule of law or abject ignorance for what the rule of law means in a democratic society. I can see Irene is saying that I'm close on time, so I'll wrap up. That, of course, doesn't cover the powers under Schedule 2 of the Withdrawal Agreement Act. They are in the nature of powers, not obligations. So surely Edwin Poots can say, well, no one can force my minister, me as a minister, to use these powers. But again, under the Withdrawal Agreement Act, the protocol is now part of domestic law. Donaldson himself has said that can't be denied. The obligations, the liabilities arising out of it are binding on public authorities. And the problem for Donaldson is this is steaming towards a head at exactly the same time he's trying to set deadlines and say, if my ministers are prevented from blocking this in a certain time frame, I'm going to collapse things. Well, next month, there is a legal challenge to Edwin Poots' activities coming before the High Court in Northern Ireland. And I cannot see, following McNernn and under Section 7A of the Withdrawal Agreement Act, that there is any chance that this effort to deny a legal obligation at a devolved level is going to come off. At the UK government level, well, the really key thing to remember with the Withdrawal Agreement Act is that it doesn't modify the Northern Ireland Act in terms of the protocol arrangements. All of the powers given to the Northern Ireland Assembly and the executive are given in the Withdrawal Agreement Act. That is setting it apart from changing the Northern Ireland Act. It's getting around any claim that operating those powers somehow triggers the Patten Amendment. I think both sides of Donaldson's strategy fall down, and I think this game of pass the parcel can be ended by judicial review. But I'll leave it there now, guys, and hopefully that's added something to this mess that is trying to make sense of the protocol and how it's going to work in the months ahead, if we still have a protocol by that point.
Okay. Hi, can you see my screen and hear my voice? Perfect. Thanks, Irene. Thanks. Yeah, and your pronunciation of Hedith was perfect. If I can say, I probably have mispronounced her name. And Joe, you can handle. Okay. So thank you. And can I just say a thanks to Jane in particular for the invitation to participate and for giving us an opportunity to reflect on the challenges of operating within a system of overlapping competences, mixed competences, where we have such weak interparliamentary and intergovernmental systems for managing that overlap. And I also want to say how wonderful it is to be in sessions where we have space for each of the different parts of the UK to really have an opportunity to hear from those, rather than sort of the devolved aspect just being a tack on at the end of a session. So obviously we're reflecting on Wales and its experiences. And and how it's been confronting the issues of the ongoing competence issues that affect Wales. Just a quick overview of where we're going to be going in our presentation this morning. Just outlining something of that story of the story of the development of competence, of legislative competence for Wales. We know that the devolution settlements are all very different, and Wales had a very different starting point from Scotland and Northern Ireland, and has travelled a substantial distance since the 1999, 98, 99 commencement of devolution. So we're going to tell something of that trajectory and of a growth in powers that we've seen, sort of successive steps to develop that competence, and the Welsh government and the Welsh and the Senedd sort of saying very clearly, we will be using these. This will be for made in Wales legislation. But that story of sort of progressive expansion in competence having very clearly been challenged by Brexit. And we've seen some highly politicized, significant sort of re-centralizations, very political controversial sort of re-centralizations of competence, both de jure and de facto. That we've seen changes in the settlements, but we've also seen the introduction of legislation that sort of de facto sort of hollows out competence. But what we want to pull out as well is that though that sort of quite confrontational story, that highly politicized story of what's going on is of course only sort of part of the picture about existing and operating within the UK system. Because what we also see is a very heavy reliance by Wales, and this is replicated elsewhere, but we see it heavy reliance on the UK Parliament and the government to continue to legislate for Wales and to use powers in otherwise devolved areas on matters that are quite sensitive, politically sensitive, and doing this through primary and secondary legislation. And we say that, of course, this is a pragmatic response, and it's perhaps unavoidable in the circumstances, the timescales that are at play here, and the sheer weight of legislation that has to be moved through. But it does sit very uneasily in this highly charged political context. And there's also sort of acceptances that we see the Welsh government making, agreeing to particular courses of action, where it is depending on a set of intergovernmental institutions and instruments and commitments that are really, we know are perceived as not being fit for purpose. And generally we say this raises concerns about the Senedd's, in particular the Senedd's role, and its ability to hold, particularly the Welsh government, to account. So that's where we're going with this. I'm going to focus on primary legislation, and the head is covering the issues of the use of secondary legislation in areas of devolved competence. So a quick snapshot of Welsh legislative competence. When the Assembly was created, Assembly now the Senedd, it only had powers to create secondary legislation. And it was on the basis of a model of conferred competence. So a very different picture from what was seen elsewhere. And then, since then, over the last 2 decades, and through a series of legislative steps underpinned by referenda, we've moved to primary legislative competence and a reserved powers model, and that came in the last couple of years, and of course was introduced as presenting a strong and lasting settlement for Wales. And there were some voices of concern about moving to a reserved powers model because it lost some of the elasticity that was there in a conferred powered model, but that sort of bringing into alignment with the other settlements was also seen as important. But it does look different. There are a much greater number of reserved areas, and some of these seem to be sort of unclear in terms of the principles behind why particular areas are reserved. There's a large number of them. And of course, we have the same settlement that matters that relate to reserved matters are outside devolved competence. Sorry, I'm flipping around. There's also, of course, the system of legislative consent, the Sewell Convention, and its operation in relation to primary legislation coming from Westminster within areas of devolved competence. So, of course, we know that this happens. This is part of the fabric of the territorial constitution and its operation. But also in Wales, since 2013, we've also had a system of statutory instrument consent that applies to certain statutory instruments introduced by UK ministers. So what we have been seeing, of course, is certain very high profile, high level constraints, recentralizations on competence that concerns coming from UK government about how devolved competence might be used, how it might impact both on the capacity to create new international agreements with other countries, or its ability to undercut a UK internal market, that we've seen that reflected in domestic legislation. So, of course, the EU Withdrawal Act from 2018, which both introduces powers for ministers, both devolved and UK, to correct retained EU law, and Hedith is going to be speaking on those powers shortly. But also, of course, the power for ministers to freeze devolved competence where it was covered by an instrument of retained EU law. Now, that power may never have been used, but of course, it was highly politically controversial. Wales did, eventually, the Welsh Senedd did give its legislative consent to this act, unlike Scotland. And it was prepared to do so following changes on the face of the bill, but also there was an accompanying intergovernmental agreement, a memorandum of understanding. And I thought I'd raise this just now because this is something we see repeated. There are situations where Wales refuses, the Welsh Senedd refuses to give legislative consent to this legislation, but there are also situations where it will, so we'll look at particular instruments of primary legislation where it does give its consent. But in a lot of these situations, it's doing so on the basis of political commitments that aren't necessarily reflected in the legislation itself. And we sort of see that first coming out in relation to the Brexit legislation, starting with that Withdrawal Act. And then, of course, we have the Internal Market Act, which carves out new areas which were contested in terms of whether or not these were reserved or not, but sort of bringing back new areas of reservation. And also, as we know, sort of hollowing out the potential effectiveness of regulatory competence through the use of these market access principles. Also should mention those pieces of legislation that have followed international agreements that the UK has reached with the European Union. Both the Withdrawal Agreement, the piece of legislation that followed that, the EU Withdrawal Agreement Act, which the Senedd refused to give consent to, and then there was no vote held on the Future Relationship Act, which brings in the Trade and Cooperation Agreement, which is that forward-looking new agreement between the UK and the EU. And what both of those agreements demonstrate, I think, of course, the profound weaknesses that are around the mechanisms for the devolved administrations, devolved governments, the devolved parliaments to feed in to any international relations, to feed into any trade policies. And they were reflected very clearly in those processes of leading to agreements with the EU. And that's despite commitments that are there in the 2013 memorandums of understanding and concordats about how the devolves will be involved in EU-related matters. And so I think, we reflect there on the concerns that that we might have going forward, we do have going forward in relation to any new international agreements that are reached with other trading partners, other potential trading partners And of course, the concerns being the impact that they might have on devolved interests and competences. But what I also want to pick out in particular are that run of primary legislation that is ongoing, where we see the UK Parliament legislating to replace existing governance systems, existing legislative frameworks that were created through EU law with domestic ones in those areas where these sort of overlap with areas of devolved competence. We see it in just a few of the examples here: healthcare, agriculture, fisheries, and then under consideration at the moment, sort of procurement, subsidies, professional qualifications. So these replacements, but what we're seeing are, of course, in terms of the systems that are in place for devolved governments and parliaments to feed into the creation of those systems. This is separate to that common frameworks process that is sort of running alongside. But so we have these instruments, these primary legislative instruments being proposed and being adopted. And as we've reflected, that there are rather inadequate mechanisms for the devolved levels of feeding in to the creation of UK-wide legislation. Now, in some of these cases, the UK Parliament is sort of stamping a reserved competence on particular aspects of those pieces of legislation. In others, it's recognising that, yes, this could be done by the devolves. There's an interest in doing it in common. But sort of examples where there is sort of a difference of opinion, where there is that overlap, and the UK government has said it's not looking for legislative consent because reserved competence kind of overtakes devolved competence in those areas. We see that WTO provisions of the Agriculture Act, for example. What we also see is when we are hearing from the devolved parliaments, the devolved institutions, and in reflection on whether or not to give consent, there are from the Senedd, from its committees, repeated concerns about how this primary legislation is having an impact, maybe not, clearly not as high profile as we see under Internal Market Act or Withdrawal Act, but that it is creating certain sort of controls and constraints on devolved competence. You see this with creating of new concurrent ministerial powers, so giving powers to UK ministers where perhaps they weren't there before, or requiring new sort of consent requirements if Welsh ministers are using powers. So although we've got a story of issues around sort of limitations on competence, what we pull out as well is the fact that even though there are all those concerns, Wales is still requesting that in areas where it could otherwise legislate itself, that it's requesting that the UK legislates for it. And so that there are provisions for Wales in acts, including the Agriculture Act, the Fisheries Act, they're suggested in the Procurement Bill. And in part, this is simply sort of to manage a workflow, that there's an intention to subsequently develop a Wales, sort of a made in Wales piece of legislation in those areas. But as we say, we think it's worthy of note that in areas which, there are going to be differences in policy and perspective. And of course, we have the different makeup of the governments across the different parts of the UK. There is still that reliance on working together, despite the sort of the limitations within the systems, the interparliamentary and intergovernmental systems. And then just my final point before I hand over to Hedith, talking about the secondary instruments, is just to bring out again that, as you say, those consent requirements, when they have been granted, that they've been relying on commitments that aren't necessarily on the face of the bill. And there are issues there with accountability, with transparency, with holding the government to account, making good on those matters. Okay. So handing over now to Hedith.
If we have around 5 minutes, of course, we can go a bit longer, but just to make you aware of the time. Thank you very much.
Okay.
Thanks, Elena. Joe, do you want to stop sharing screen and I can share mine?
Well,
Technical wizardry. Here we go. Brilliant. Thanks, Joe. So yeah, I just want to focus a little bit on how this stuff and how this narrative plays out in the secondary legislation passed to deal with Brexit. Not to repeat points already made, but just as a reminder, the 2018 Withdrawal Act introduced or gave powers. I focus on the as enacted because, as we heard earlier, there were new powers parachuted in from related to the protocol that were also introduced. So I'm not going to mention here, but there were certain regulation making powers provided to both UK governments and to the devolved governments under the Act. And some of these powers can be used only by UK government, and others of these can be used either by UK government and Welsh ministers acting alone, jointly or concurrently. Some of these powers are also required to be sifted by parliamentary committees, others are not. And so in their scrutiny of the bill and anticipation of the debate on legislative consent, the Welsh Government were very clear that there would be a likely increased scrutiny burden that would then follow upon the Senedd as a consequence of these new powers and as a consequence of the new sifting procedure in particular. And the decision was made after the Act received royal assent that certain changes needed to be put in place by the Senedd to address this increased burden. And so in relation to Welsh government-made SIs, we had the Constitutional Legislative Affairs Committee at the time, since changed its name to be the Legislative and Justice and Constitution Committee. So was given the responsibility to be the SIFT committee. It is the committee in the Senedd that is normally responsible for the scrutiny of all statutory instruments. And a protocol was agreed between the committee and Welsh Government to ensure that the Welsh Government would give the committee early notice, 2 weeks notice, of any regulations made under the Act. Then in relation to UK government-made EU exit SIs, we already had a procedure in place, introduced in 2013, that the Welsh Government would notify the Senedd and introduce a statutory instrument consent memorandum where a UK government any UK government SI amended primary legislation in devolved areas. Now, this procedure was enhanced as a response to the bill, and a 30C written statement procedure was introduced, whereby the Welsh Government would now notify the Senedd of any EU SI created in devolved areas by UK government. So we had this, and the Senedd had an understanding that both of these procedures needed to be enhanced, but the concentration of resources was put into the SIFT and into the understanding that there would be an influx of regulation of the use of the regulation making powers by Welsh Government and not UK government. However, what came to pass as early as November 2018, as we can see in the statement by then First Minister Carwyn Jones, was a change in the Welsh Government's approach. So what we have is the First Minister saying, I think in one of his last committee appearances before he stepped down, was that they needed to reverse the position, that the circumstances are exceptional, and where there is no controversy as to the subject matter of the instrument, we're talking about highly technical, non-controversial matters, where there's no policy divergence or no likelihood of one, then the Welsh Government is happy to give consent and the responsibility to UK Government to create these instruments on its behalf. And this approach was taken up and taken over by First Minister Mark Drakeford's government in the next in his government too. So this approach has really continued in the latter part of the fifth Senedd. But as the legislation and justice and continuation, sorry, as the Legislation, Justice and Constitution Legacy Reports Committee's legacy report at the end of the fifth Senedd broke down, it was clear that this was unexpected, and that they had some serious concern about the use of these powers, because what transpired was an increase in a significant increase and an unexpected increase in the amount of UK government EU exit SIs put forward, to the detriment of the EU exit SIs by Welsh government. And the committee notes that when the National Assembly agreed the LCM on the 2018 Act, it seems to us that it did so in part, at least, on the basis the Welsh Government had secured amendments to the bill that gave the Welsh ministers additional powers to make regulations. Now, the Welsh ministers are not using those powers extensively. Instead, they're relying heavily on UK ministers to make regulations that correct EU-derived domestic legislation in devolved areas, and they're relying completely on UK ministers to make regulations that correct direct EU legislation in devolved areas. So there's a key point of concern there raised by the committee. Had the Senedd known how these powers would be used, would they have consented to the legislation when they were considering the LCM? And to illustrate a further difficulty, I want to just pick up very quickly. No, I know we're running out of time, but I will just mention this very briefly, is that it's not just a question of what the Welsh Government is saying about the technical nature of these issues, but even when there's a dispute between Welsh Government and UK Government on whether an issue is devolved or not, the Welsh Government is still content to consent to UK SIs made in those areas because of the technical, non-controversial nature of those regulations. And this is what we see in terms of geographical indicators. It's an area where Welsh Government is certain that it's a devolved area, and for the UK Government, these are areas of intellectual property, and that's a matter that's reserved. We know this is also intrinsically linked with the UK Government's need to adhere to WTO provisions. This is an area that was also obviously overseen by EU law previously as well. And the October 2020, we see a regulation being put forward by UK Government, does not ask Welsh Government for consent because it doesn't think it needs to, because it doesn't believe that these policies are devolved. And nevertheless, the Welsh Government does notify the Senedd of the regulations, and then says, but these are technical, so despite the fact we disagree on the overarching policy, we're happy for these regulations to be made. I'm cantering through this now because I'm aware that I'm running out of time, but to highlight that we would not know the detail of this had the committee not corresponded subsequently with Welsh Government on this matter. And we're told that the Welsh Government has yet again received intergovernmental assurances as to the operation of the scheme. There's apparently a dispute resolution procedure put in place. It hasn't been published, and that the Welsh Government will be given input into the scheme and how it operates. So again, we can see the distinct difference between the high-level politics and political narrative in this area and the pragmatic approach of the Welsh Government to the UK Government's action, reliance on intergovernmental assurances, and the reliance on the UK Government to legislate in this way is just surprising, given the difficulties between them. I don't want to disparage the Senedd completely, because they are acutely aware of these issues. The chair of the committee that made some of these recommendations in the 5th Senedd is now Counsellor General. So we will see whether there's any change to this approach in the now the 6th Senedd, and what steps the committees will take in order to try and at least tease out a strategy by Welsh Government as to why it takes this approach, and for us to get more transparency in this area. I'll stop there, Ines.
Thank you. So since writing the abstract for this paper, I've decided to reorientate the focus, if not the content on it. So the coverage is broadly there, but moving away from that gap between myth and reality that I hope to come back to, towards the question of intervention. And a lot of this was actually reinforced by some of the discussion that we had following the papers yesterday about devolve and control, rather than devolve and forget in the international relations sphere. So when the Co-Brandon Commission reported in 1973, laying the groundwork for aborted attempts to devolve power to Scotland and Wales in 1978 and 1979, the report listed 2 essential features of this non-federal model, i.e. a model of devolving power but retaining sovereignty at the centre. And however unlikely the Commission expected these powers to be used, those 2 essential features were: first, devolution should not affect the paramount power of the UK Parliament to legislate, including against the wishes of the devolved institutions. And second, and I think interestingly, the report placed this on the same fundamental level as that manifestation of parliamentary sovereignty. Secondly, powers of veto were necessary to ensure compliance with international obligations or to protect the political and economic unity of the UK. So 2 essential features are essentially legislative and executive intervention in the devolved sphere. Now, the logic of Co-Brandon prevailed when devolution was delivered 20 years later. The Parliament's retention of legislative sovereignty is expressly contained within section 28(7) of the Scotland Act, and the powers of the Secretary of State to veto Scottish bills or to prevent or require ministerial action on the part of the Scottish ministers are contained in section 35 and section 58 respectively. But until Brexit, and when I refer to Brexit here, I mean broadly as a process rather than as the moment of withdrawal. So going all the way back to the general election that gave us the majority, that gave us the referendum. Until Brexit, these powers had not actually been used. They were essential but unused. In the latter case, the veto power doesn't seem seriously to have been contemplated at all. Now, to these powers of intervention, we can add to the 1998 model a third. In 1978, 1979, it was thought to be an affront to devolution, that devolution would be constrained by hard legal boundaries. But of course, the 1998 model is one in which judicial review of devolved actions, primary legislation, secondary legislation, and other actions by Scottish ministers are significant. And so reflecting that, section 33 of the Scotland Act allows for the UK law officers to refer a bill before it's enacted to the Supreme Court where there is a doubt about legislative competence. And again, unlike the experience in Wales where the reference procedure had been used, until Brexit, that reference procedure for 20 years of devolution had gone unused. But since Brexit, we've seen a much more muscular form of unionism that's emerged. I've described it here, maybe a bit exaggerated, but for effect, an attempt to impose the logic of a unitary state on top of a much more territorially complex and pluralistic reality. What we're seeing, in other words, is these tools of intervention going from non-use in quite a sudden and concentrated period of time to quite significant use. And what I want to point out is that that's not just about Brexit and devolving control in the Brexit realm or in the international realm. We'll conclude, hopefully, if I have time, to say that there are broader constitutional implications that arise as a result. So the first question I might ask is, why are these powers of intervention, why were they unused in the first 20 years of devolution? At least of devolution in Scotland. And we can point to a number of factors. So if we take the veto power described as essential by the Co-Brandon Commission, despite asserting their right to use the Section 35 and Section 58 veto powers, in a memorandum of understanding, the UK government recognised that this is a nuclear option, that the UK government should aim to resolve difficulties through discussion, quote unquote, and, quote, it would be very much a matter of last resort. On top of that, the existence of the power, the mere existence of the veto power, we know, although we can't record, impacts behaviour at policy formulation and pre-legislative stages. And therefore, there are no surprises at the end of the process when legislation is made or ministerial action is taken that takes us towards the boundaries, the sorts of boundaries that the Secretary of State might wish to protect. And then thirdly, until Brexit, much of the scope of activity that might be covered by the veto, that might require the veto to be invoked, was conducted through the level of the EU in the formation of trade deals and so on. And so governed by an EU approach by EU actors or UK actors feeding into the EU, rather than a bilateral approach between the devolved nations and the UK. So these factors sort of obviate the need to use the veto in these first 20 years. In terms of legislation, why have we not seen legislative intervention? Well, there's a genuinely held desire to make devolution a workable arrangement. There was, in the early years of devolution, a very comfortable relationship between the party of government in Scotland, the Labour-led Lib Dem coalition, and the Labour Party at the UK level. And when that moved from that very comfortable relationship, it moved suddenly to a very high stakes relationship between the SNP and the Conservatives, with nationalism, with the prospect of an independence referendum in the background. It was not in the UK government's interest to be seen to intervene in the devolved sphere, because that could provoke a nationalist backlash and provoke rising support for independence. There are, of course, constitutional safeguards against the unwelcome legislative intrusion by the UK Parliament into the devolved sphere. And those safeguards, mainly the Sewell Convention, have largely, until the Brexit process, been respected, even where there are high stakes political and constitutional matters at stake. So, for example, when the Scottish Parliament at first refused legislative consent to the Scotland Act, what would become the Scotland Act 2012, the then Secretary of State for Scotland, Michael Moore, argued that, well, of course the UK can simply legislate anyway on its own terms. But what in fact happened behind that rhetoric was that concessions were made, a bill that was mutually acceptable was found, and it passed with consent. And then finally, with regards to the Section 33 reference, the non-use of the reference during the early Labour years meant that when disputes could be resolved by a phone call from Blair to McConnell or however that might be done, then, which meant that these mechanisms didn't really mature, didn't really evolve, and meant that the pressure was building on the first time that they were used. The longer that the reference procedure went unused, the higher the stakes, the more pressure there would be when it was finally deployed to refer the Scottish Parliament's legislation to the court. And we know that from interviews conducted with UK government officials, two factors that strongly calmed the use of the veto power. One was that effective pressure, not wanting to be the one that presses the nuclear button. The other is the effective nationalism, for the UK government to refer SNP, Scottish Government legislation, to the UK Supreme Court in order to stop it from having effect. could provoke nationalism with the prospect of independence referendum in the background. But there are also more mundane reasons. One is that even though the Scottish Parliament had legislated towards the boundaries of legislative competence as regards its international obligations, legislation that pushed at the convention rights boundaries, such as around asbestos and A1P1 for damages, legislation that pushed at the EU law boundary, such as legislation to impose a scheme of minimum unit pricing. Even though the Scottish Parliament has pushed at those boundaries, for the UK government, for the Attorney General, they're much more concerned about what's happening at the reserve devolved boundary. Although these intervention powers are largely directed at securing international obligations or unity in terms of international obligations, when it comes to the push, what the UK government and its law officers are most concerned by is internal constitutional arrangements, the reserve devolved boundary. They can always push the convention rights arguments to an external party to challenge later, such as the big insurance companies, the tobacco companies, the alcohol companies. They can always push the EU legislation to post-enactment challenge. They can always pass the buck, in other words, when it comes to those boundaries. And also there's significant areas of policy convergence. So for example, something like minimum unit pricing might raise questions of competence, and did raise questions of competence at the EU law boundary, but there was policy convergence. There was an interest in the UK government seeing how minimum unit pricing would work in practice. That probably meant that they were less willing to test its legality and to leave that question to be tested elsewhere. So the first 20 years of devolution, in other words, are marked by essential tools of intervention, but nevertheless blunt tools of intervention that could provoke political crisis if used, and therefore a non-interventionist approach, disincentivized from using these tools in order to intervene. So the next question would be, well, how has Brexit changed that dynamic? I'm not intending to be comprehensive here, but just to pick out some staging posts along the way. In the early stages, it became quickly clear that the unitary approach to Brexit and the kind of union state approach to Brexit, that we would only engage in this process when the Welsh, the Scottish and the Northern Irish devolved institutions had had their say, would give way to a unitary approach. We joined as one UK and will leave as one UK. EU law or EU membership is a reserved matter, and therefore it's to be dealt with solely at the UK level. But this unitary state approach concealed much more than it revealed. So in 2016, ahead of the UK general election, the Scottish Parliament election in 2016, the SNP pre-Brexit referendum had already said that Brexit itself would pose a material change in circumstances from 2014, such as to justify asking again the independence question. The devolveds were already thinking seriously about what Brexit would mean as a union state approach to Brexit might look like. So, for example, it might have been political opportunism. It might have been unlikely ever to happen. But when the SNP proposed a four-nation lock on the Brexit referendum, in other words, a requirement for parallel majorities, yeah, that might not ever have been realistic, but it did show some thinking about how it meant to be a union state that recognised the autonomy and the dignity and showed respect to devolved nations. That might never have happened, but it should have provoked a more subtle thinking about how we can accommodate that territorial reality through the Brexit process and its outcomes. The 2016 referendum, of course, offered a territorially divergent result. Brexit majorities in England and in Northern Ireland, in Wales, remain majorities in Scotland and Northern Ireland that pointed to a degree of political difference. And in Scotland's place in Europe, a paper produced by the Scottish Government in 2017 or 2016, again, the devolved nations, even the nationalist Scottish Government aimed at securing independence, was thinking seriously about Scotland's place within the Union and how a number of options might allow for Scotland to remain aligned to aspects of the European Union and in particular to the single market. And then finally, in 2017, the EU Notification Act, which would pave the way for our notification that we would be leaving the European Union and start the clock ticking on that Article 50 process, was enacted against the Scottish Parliament's wishes. The legal significance and the constitutional bite of the Sewell Convention, that safeguard against this from happening, having been significantly reduced or blunted by Miller 1, by the court's assertion that despite the Sewell Convention being replicated in statute, that this was not a fulfilment of the Smith Commission's commitment to put Sewell on a legislative footing. All that it had secured was that the legislation had recognised the prior existing political convention. It had no legal force, it had no legal bite. And so Article 50 was notified without any significant input from the devolved nations, without their consent, and without any ability, therefore, to influence Brexit negotiations and what the domestic implications of Brexit outcomes might be. So Brexit forces us into a confrontation with diversity, with the pluralistic nature of the UK's territorial constitution. We see electoral differences in the 2015 general election and in the Brexit referendum. We see constitutional differences. The Scottish Government and UK Government did not agree that Sewell applied to the EU Notification Act, the UK Government arguing that this was a reserved matter and therefore Sewell was not engaged at all. And we see significant political differences. The Get Brexit Done, the UK nationalism, the unitary state approach that quickly emerged when devolution became a wee bit too difficult for the UK government to handle, matched with the, was countered by the language being used in the devolved nations, particularly in Scotland and Wales, language around the UK as a voluntary union of nations, an attempt to counterimpose the narrative that underpinned the union state approach and the control that we saw. But this also has practical implications when we talk about international trade and we talk about international obligations, which is that if one of the things that held all this together was that, well, okay, but a lot of this is all done at the EU level anyway, and therefore we don't need to have confrontation, we don't need to use the veto power, we don't need to refer these bills because it's happening at a different level of constitutional authority, then Brexit means that we might have to face up to confrontation much more regularly. As Joe and Hedith pointed out, there are a number of overlapping legislative areas in terms of devolution and UK legislation. Trade deals will now be conducted more often, guided by a UK government approach, and we lose the tripartite relationship of devolved EU and UK to a bilateral relationship, which again exposes us to the balance of power in those areas. So how is this control, or how has intervention manifested itself in light of this? Well, regards to the Section 33 reference, unused until the Brexit process, it was a Brexit bill that was the first bill that the UK government decided to refer to the Supreme Court, the Scottish Government's continuity bill. So the Scottish Government felt that it could not offer legislative consent to the UK Government's continuity bill. That would provide for the continuity of EU law after Brexit, as I'm sure you all know. And so not simply to block that legislation, or at least to withhold its consent to that legislation, but reacted by passing its own continuity bill, initially alongside the Welsh devolveds as well. That bill would have similar provisions to the UK bill, but it would also go further in certain respects. So it would restore rights to Frankovich damages, it would restore certain rights of action for breaches of EU law, retained EU law, and it would retain the Charter of Fundamental Rights as an aspect of retained EU law. So there would be a higher level and deeper level of rights protection. That was referred by the UK government to the Supreme Court, despite the political stakes being high, despite the previously constraining impact of nationalism and the prospect that this might provoke some sort of national support for nationalism and support for Scottish independence. But it was also a tactical use of the reference by the UK government, using the delay between the making of the reference and the hearing of the court to amend the Scotland Act by virtue of its continuity bill to make its own continuity bill a protected statute, protected from amendment by the devolved legislatures, and therefore to make these areas where the Scottish Government sought to go beyond the UK Government in its approach, for example, by maintaining the Charter on Fundamental Rights, to render them incompatible and therefore ultra-vires. And also, although the UK Government justified this in neutral terms, recognising that it was politically loaded, justified it in neutral terms, it was in fact a subtle attempt to undermine devolution. The arguments that the UK Government made in court were not made in neutral terms. This was not us simply seeing whether the bill was within competence. There was an attempt proactively to argue for a narrower understanding of devolution in principle and in practice. As regards the veto power, although still unused, it has been openly contemplated. So in Conservative MSPs in particular, both in the blogosphere and in committee, have pondered making ordinary the use of this nuclear option as a means of constraining the Scottish Government and the UK and the Scottish Parliament when it comes to devolved legislation and ministerial action, which I think betrays a lack of serious thought about how we can think as a union state pluralistically and include the devolved, carry the devolved with us in our approach to Brexit. And then in terms of legislative intervention here, we've seen probably the most dramatic circumstances come to pass. So there have been at least 3 pieces of Brexit legislation that have been passed over the heads of the Scottish Government against their consent. These have significant impacts in terms of constraining the Scottish Government and the Scottish Parliament. We look at the Continuity Bill, legislation passed knowingly against the consent of the Scottish Parliament, where it was recognised that seeking consent was necessary, and how that undermined, for example, the attempt to ensure higher respect or higher and deeper commitment to rights protection. We've seen the Internal Market Act, which arguably hollows out or constrains and devolves through market access principles, through powers of the UK Government to spend directly in devolved areas, and in the Subsidy Bill, which is likely to pass without legislative consent, which creates an unbalanced system to replace state aid. Now, if I can just move very quickly, I'll finish on the point that I wanted to make, that this is not just about devolution and control in the Brexit sphere or in the realm of international obligations. There are broader constitutional implications that have come into play. The Section 30 reference has been used once, and now it's been used again in a different area with regards to the to children's rights protection and the status of local government, challenges that are still to be decided upon, but were heard a few months ago. So once used once in the Brexit area, it's now being used more freely in other areas, and we can expect, I think, an assertive UK Government to continue to use these powers where it feels necessary. The UK Internal Market Act has started, people have started to contemplate its use in areas that are far removed from simply allowing the movement of goods or services within the UK. So yes, there might be an argument, I'm sure some in the Welsh would argue against this, there might be an argument that the M4 Relief Road and the promise to spend in that area against devolved consent might somehow facilitate the free movement of goods on better roads. But there's certainly not an argument around the politically loaded offer of the UK Government to spend in areas such as education in Scotland, or to spend on rehabilitation services to cure the problem of drug deaths. What starts off as a Brexit problem becomes a much wider constitutional problem that asks questions of constitutional legitimacy and democratic accountability. And even at the high level, I think what we're seeing here is what I pointed to in the Edmund Morgan quote from the abstract, that reform happens when constitutional fictions, the stories that we tell ourselves about the Constitution, become so stretched from political reality that we are no longer willing to suspend our disbelief that reform is needed to bring these fictions and reality together, to re-strengthen or to reconvene our willing suspension of disbelief in authority. Devolution was born of such a moment when parliamentary sovereignty was seen to be abused by the UK government in the imposition of poll tax, for example, and when democratic deficit put Scotland in a precarious constitutional position, a separate claim for legitimacy beyond parliamentary sovereignty was made. That was a claim for the sovereignty of the Scottish people, expressed through the Claim of Right and the Scottish Constitutional Convention. And for however fleeting that was, it was constitutive. It created the blueprint for the Scottish Parliament that we see today. I think we're in a moment now where competing claims are being made for authority, and where the fiction of the possibility of a unitary state approach that we've seen through Brexit and in the UK government's attitude to international relations more generally can no longer hold against the reality of the pluralistic nature of the territorial constitution, of devolved autonomy, of the overlap between devolved and reserved matters or international trade matters in devolved policy areas. That claim is being expressed through the unitary approach, the muscular unionism approach taken by the UK government and given force through things like the UK Internal Market Act. But that rival claim that this is a voluntary union of nations, not simply made by the Scottish government, but also from Wales, which gives it some greater currency, seems to me to be a claim to reorientate the myth and to reshape political reality in that direction. And where that matter, how that claim is resolved and to what end, we don't know. But it seems to me that we're approaching breaking point when these two narratives can no longer sit together. So I'll leave it there, thanks.